Are you a wholesaler or thinking about getting started in wholesaling? Well, a question that comes up all the time is whether or not you need a limited liability company to start wholesaling. Well, in this video, we're going to talk about that particular topic. All right, let's get started. So here's the deal. Do you need to set up a limited liability company to go out there and start wholesaling? This question comes up all the time. If you look at Bigger Pockets and other listservs like that, people are always wondering, hey, do I need to get this complex or can I just do it in my own name? Well, obviously you can do anything in your own name, but the question is it wise to go out there and wholesale in your own name? And a lot of people will tell you, listen, you don't own the property, you have no liability, all you're doing is tying a piece of property up under contract and then you're flipping that contract. So what could go wrong? Well, that's exactly what happened, or that was the thinking behind an individual I recently ran into who was wholesaling in their own name, and they found out the hard way that by not having an entity, it exposed them to liability. So what am I talking about here, and what should you be doing as a wholesaler? Well, let me just show you. So this individual, what they had done is they did what most wholesalers are going to do. They found a property and they tied this property up under contract. And then they found their investor over here. And so then they flipped the contract to the investor who then closed on the property. Now, the problem happened to be is that with this particular property right here, there was a serious toxic mold problem they found after closing. And the investor then said, well, wholesaler, you should have found out about this and informed me of the fact that this property had a toxic mold issue. Now, before all of you that are watching this video run off the handles and start dropping comments, it's not the wholesaler's responsibility to do a property inspection and determine whether or not there was mold. That doesn't matter. You see, the common mistake people have in thinking about lawsuits or understanding of lawsuits is that you actually have to do something wrong in order to be sued. Quite the contrary. It's oftentimes the case where somebody has an grievance and they're looking to get paid because something didn't work out the way they had hoped it would, and they just start naming everyone that was attached to that transaction. So if you're the wholesaler, you're definitely going to be named in that lawsuit. And the problem then becomes is if it's you as an individual, which happened in this case, this person turned around and sued this individual wholesaler, then you have to defend yourself, because if you don't, they'll get a default judgment against you. And then all of your future real estate investing will now be put at risk. So this particular situation, the individual reached out to us and they said, what do I do? Well, unfortunately, the horse has left the barn. There's nothing we can do for you here. And this is why it's so imperative that if you're starting out with wholesaling, or maybe you're currently wholesaling and you're doing it in your own name, you're doing it all wrong. What you want to be doing is you want to create a business structure, typically a limited liability company for your wholesale deals. Because in the facts of this particular case, had this gone down this way and this individual had been investing through a LLC, that is putting together their wholesale deals. So when they find a house, what they will do is tie this property up under contract in the name of their limited liability company. Now their LLC will in turn flip that contract to the investor. So the LLC is in the middle of the wholesale deal, not the individual. So let's assume that this were to play out the exact same way, where the investor bought the contract, closed on the property, found the toxic mold. Now, who do they sue? They sue the party they bought the contract from, which is going to be this limited liability company. Now, as a wholesaler, one of the things you have to become accustomed to is not keeping a lot of assets in your LLC. And this is a mistake I find many times with individuals who are wholesaling, is that they don't appreciate the fact that they don't allow cash to accumulate there. Pull it out. Sometimes people tend to look at this as a secondary bank account maybe. Oh, I know I can get the money out at any time, but that can be a huge mistake, because if you allow your wholesaling profits to accumulate, and I know some of you say, well, Clint, I'm wholesaling because I'm trying to generate income to live off of. I appreciate that. I understand that. You'll be taking distributions out. But some people do leave distributions in. This is a scenario where you should not be leaving any money inside of that company. Take all the money out of your LLC. Maybe you leave, $500 or $1,000, whatever you're going to need for earnest money to tie up your next deal or so in that limited liability company. But get the assets out of there. Don't leave the money sitting around, because if something like this were to happen, then those assets are going to be locked up. So what a LLC will do for you as a wholesaler and why it's so important is that it provides a shield from your deals that go bad so that they do not sue. That is, the investor, the person you flip the contract to, is not suing you personally. What they're doing is they're suing the limited liability company. And that's the idea here. We do not want to be named personally in a lawsuit. Now, I just gave you in terms of the context of an investor suing you, but liability also exists in the context of a seller. So let me just show you a different scenario here. So let's assume that I find this property here, and here's the seller I'm working with, and I enter into a contract to purchase this property. Now, the problem is I've entered into this purchase and sale agreement with this seller, but I cannot find a buyer to close on this deal. So then I do not close on the property and I walk away from it. Now, many of us are under the false assumption that the only risk I have is my earnest money that I put down in under the purchase and sale agreement, that I gave this to the seller. Because most of the times in wholesale deals, we're not going to have contingency clauses, or you'll have very few in there. And that is to entice the buyer to enter into this agreement with you. But if this were to happen and you were to walk away, I've seen scenarios where the seller has sued the wholesaler for not closing. And you know what? The earnest money was not their only remedy here under the agreement. In fact, under common law or under state law, you're allowed, that is, the seller can sue the purchaser or person who tied the property up under contract, the offeror, can sue them for specific performance or for damages. Now, if you're wondering where are the damages, well, I dealt with a case just like this where the seller sued the wholesaler stating that the property had gone down in value because they took the property off market while the property was tied up under this purchase and sale agreement that the individual wholesaler failed to close on. So that's a great example of where now you get drug into a lawsuit where you don't want to be involved in, because if you're drug into that lawsuit, then that's going to prevent you from moving your business forward because you're going to be fighting that case. So again, keeping that entity in place before you make an offer is really important. And that is why it leads me to a point I want to make sure you understand. When you're making offers, always make the offer under the name of your business. Do not put your own name on there. In fact, what I like to do is make it under the name of the company that I've set up and place on there after you make the offer and or designated entity. So what does this do for you? What this language does, it allows you then to identify or the seller accepts the fact that you will close either in this company or you will close in a different entity, meaning not you per se, but your investor, that when you flip the contract to this party over here, they're the one who may ultimately close on it. And the seller has consented to that by consenting to the language in your purchase and sale agreement. That's really important. I hope you wrote that down. You put the name of your entity and then you place and or designated entity. So if this was Crazy Chicken LLC and or designated entity is how I would make my offer to close on this property. So that's a really important point here when it comes to doing this, to make sure you can always assign those agreements off. So wholesaling, listen, do not mess around. Get yourself an entity set up before you make these deals, and always make them in the name of the LLC to make sure that you're protecting yourself. Hey, if you're new to my channel, now's an opportunity to subscribe. And if you like the video, be sure to smash the like button. Take care.